A plan to make repeat drunk drivers wear ankle bracelets is off to a slow start, and lawmakers are being asked to tackle other solutions to help curb drunk driving. Gina Mangieri is always investigating and digs deeper into what's working and what's not. Gina?
Well, we told you about the expanded SCRAM ankle bracelet system being put into place last November, but there are mounting doubts about how effective that court-ordered blood alcohol monitor will be.
Judges can mandate ankle monitors for repeat drunk drivers under a program still at the pre-rollout stage.
Even with the ankle bracelet on, you can still drive drunk. We do find it to be a nice deterrent to not getting an interlock.
Currently, people going through DWI court can voluntarily wear ankle devices made by a company called SCRAM. In the new court-ordered program yet to launch, a judge would decide, not the person charged with drunk driving.
Do you anticipate that this ankle bracelet, if court-ordered onto somebody, would likely face some kind of challenge by their defense attorney as a civil rights issue?
I would think so. The fact is that none has ever been ordered yet, so there's no case to challenge.
Always Investigating learned there's no case to challenge because the judiciary is still working on rules and guidelines. It was supposed to start at the end of this month. SCRAM is already contracted to provide the devices, estimated to only be a couple dozen.
If you're the attorney for the person that's standing there getting this ordered, what are you going to say?
Of course, I'm going to argue against it. Look, this would be a terrible inconvenience for him in whatever fashion. Perhaps it's a security clearance issue stating that this current offense has not been adjudicated. We maintain his innocence. If they violate that, any alcohol is detected within every 30 minutes. They could very likely be sitting back in jail until their trial date. And often these things go on and on and on.
Before even ending up in front of a judge, though, big changes could be coming in how police get proof of intoxication on the road to combat an issue from a few years back when asking for breath was deemed a warrantless search.
It's largely been overcome now. In 3 of the 4 counties, police are allowed to call a judge at 3 in the morning and say, I need a warrant to draw blood from this guy, and they'll get the warrant. Oahu doesn't have that yet, but there's a bill this year to permit that.
Defense attorneys say those electronic warrants, essentially voice recordings of a judge's permission to take personal samples, will likely end up challenged all the way to the Supreme Court. We'll watch how those warrant measures evolve this legislative session. And as for the ankle monitors, no word yet on the cost spent so far or budgeted for it, or when the courts are likely to be ready to issue the first order to wear one. Back to you.